Good morning. The time is now 9 o'clock on November 13th, 2025. My name is
Okay.
Albert Chang.
Oh, okay, wait a minute. The court reporter wasn't ready. I didn't
Oh.
realize, I can't see you, sir, so I didn't see you speaking.
That's all right.
Okay. Start over. Oh, sorry. You just, I wasn't ready for that.
Okay, I can start over. No worries. Good morning. The time is 9 o'clock on November 13th, 2025. My name is Albert Chang. I am the chair of New Mexico's Oil Conservation Commission. And noting the time, I call this meeting to order. If Commission clerk could please call the roll.
Okay, good morning. Roll call of the commission. Commissioner Palma.
Present.
Commission Chair Chang.
Present.
Commissioner Bloom.
Present.
Okay, we have our full quorum.
We have a quorum. So I will then proceed to the agenda for today's meeting. There has been shared with the commissioners minor modifications to the agenda that was earlier published. I recommend that we include a item to discuss commissioner availability and scheduling of the December meeting, and also of minor reordering of the cases set for status conference, moving case number 25700 up in between or up to the second case to be heard. If that is acceptable to the commissioners, may I have a motion to adopt the agenda as amended?
Mr. Chair, I so move.
Mr. Chair, I second.
Thank you very much. Is there any opposition? Without objection, so ordered.
This is the court report. This is the court reporter. This is an issue for me. All I can see is Commissioner Bloom. I assume the chair is in the room that it says Apodaca Sheila. I can't see the other people speaking, so I don't know who's speaking. Usually it shows up on my screen as their name, but apparently you all have many people in the room with you.
We do. That's
yeah,
correct.
and if they speak, I can't see who the speaker is.
Would you like us to, is there a way for us to zoom in, Sheila, so maybe the view is a little clearer?
Not that I know of. I don't.
Okay. In that case, we'll do our best to state our names before we speak. Is that might be the best we can do for today?
Yeah, because again, as I'm sure you understand, a court reporter, when somebody speaks, we got to be able to see who that person is speaking. Otherwise, it's marked as unidentified speaker. Like I said, this is Zoom. My screen shows certain people on here, but my screen for you all is showing like from here, 1, 2, 3, 4, 5, 6 people in that room, maybe?
That is correct, yes.
Yeah. I don't know who those 6 people are besides you.
We're certainly happy to do a round of introductions, but you won't really be able to see us anyway, right?
That's right.
Camera. Yeah. Oh.
No,
Not here. We
not here. We do not. You can shoot a Teams message down to forestry and ask potentially borrow theirs, but that's going to take a while to set up. It's not quick. This whole meeting is being recorded, correct?
Yes.
Anyway, are the parties all right if we dispense with court reporter transcriptions until we get to the agenda items of the status conferences? Because I don't think you need a court reporter for us to discuss approval of meeting minutes, right? Is there any objection if we?
I think there's only 3 people that are going to speak today.
Yeah.
First, I should say, my name is Zach Chandler, Commission Counsel. She's now familiar with your name and your voice. She knows who Commissioner Bloom is from the screen. The only person she probably is unidentified as Commissioner Apoma, who made the second on the motion. Does that clarify the record so far?
That does. But again, I mean, the people in that room with you, every time they speak, they're gonna have to tell me who they are. Me just trying to remember the voice. I'm sorry.
Understood.
And I'm not a new reporter. I'm done. I've been doing this for 45 years.
We understand. No, we understand. We will do,
In, so she'll see me.
we will do our best to identify ourselves as we speak. And if any of us forget, please do not hesitate to remind us. Is that all right for now?
That's all right, but you have to remember then, when I have to tell you who it is, then there's gonna be not a record there. Yeah.
We'll do,
I didn't realize
muddle-
this was gonna, I'm sorry, I didn't realize that this was gonna be multiple people in a room. Had I known that from Veritex, I would have come to Santa Fe. I'm sorry, but I was told everybody was gonna be on Zoom.
well, certainly apologize for any miscommunication that may have happened. And,
So Darren is on his camera.
okay.
You can see Mr. Savage.
I understand. So some of the attorneys in the room have laptops with them, so will log in so that you can see them as best they can. It looks like maybe everybody has laptops set up except for me at the moment. So we will also do our best to also log on so that we also pop on. For example, Mr. Savage, one of the attorneys in the room with us, is also on his computer. So when he does speak, he should pop up on the screen as well. So we will do our best to work around these challenges.
Thank you. I just wanted to give you that heads up because,
I understand.
thank you.
We appreciate your efforts and we'll do our best to coordinate and accommodate.
Thank you. And I'm sorry for interrupting you.
No, that's just fine. If I could then, if I recall where I am in the agenda, I believe we were about to proceed to the discussion of the meeting minutes for September 18th and 19th. Have commissioners had a chance to review the September 18th and 19th meeting minutes?
Mr. Chair, I was not present at those meetings, so I will abstain from voting here.
No, so present, Commissioner Ampoma. I was also not present for this meeting, but I did. So I don't know.
Do you have any additions, changes to the minutes? I believe members are, commission council can weigh in on this, but I believe members are allowed to vote on meeting minutes, even at meetings that they were not present at personally.
This is Zach Chandler, Commission Counsel. That is correct, though I think they would have to rely on maybe a statement from a person that was there that the minutes are accurate.
At least, fair enough. This is Commission Chair Chang. In my review of the meeting minutes appear accurate. In that case, I will move to approve the meeting minutes from September 18th and 19th.
Mr. Chair, I second.
For the court reporter, the second was Dr. Mpoma, Commissioner Mpoma. Is there any objection? Without objection, noting Commissioner Bloom's abstention, the meeting minutes are adopted. So I move on to item number 4 on the agenda, or at least the agenda as amended, which is a discussion about potential meeting conflicts, scheduling conflicts. Dr. Mpoma, could you refresh my recollection? I believe you may be not available on December 11th. Is that correct?
This is Commissioner Ampoma. Yes, that is correct. I'll be on international travel. I'll not be available.
Commissioners, we do have items on the docket that are likely to need our attention in December? Is there a different date that might work for yourselves?
So, Mr. Chair, I will be back to US on December 15th. That is when I'll be back.
And when do you depart?
Leaving next week, Saturday.
Oh, so you'll be gone. Okay.
They're gone for the month.
Nice. So December 15th. Is there a date after December 15th that, or a date range, Commissioner Bloom, that would work best for you?
Mr. Chair, I'm looking at my calendar right now. Wednesday, December 17th would work. The 19th would work. And then our office is closed and I'm out the rest of the year. 17th and 19th.
How do those dates look for you, Commissioner Poma?
This is Commissioner Puma. Can make any of those dates work.
17th or 19th?
Yes.
Okay. This is the chair. If members will bear with my very slow computer here, I will confirm my availability for those dates as soon as I am able. I can make myself available on either of those dates as well. The 19th is preferable for me if we could start at no earlier than, well, if we could do it in the afternoon on the 19th or, yeah, either way, 17th, I think I can make either way work. I've got a in-person meeting in Friday, the 19th in Albuquerque in the morning that I cannot move. But other than that, I can everything else.
This is Commissioner Puma. What about Wednesday, 17th?
I've got meetings, but those I can move. So if the 17th is the best date, I can block the whole day on the 17th. Does that work for all the commissioners?
The 17th would work better for me, Mr. Chair, and there's nothing I can't move around that day, so.
Great. In that case, I propose that or if I could have a motion then, to reschedule the December 11th Oil Conservation Commission meeting for Wednesday, December 17th.
Mr. Chair, I so move.
Mr. Chair, I second. This is Commissioner Puma.
Is there any objection? Without objection, the next commission meeting or the commission meeting in December will be, is now rescheduled for December 17th. All right. Thank you very much for bearing with us. Turning to the next agenda item, we move on to our pending cases. I call case Oil Conservation Commission case number 25603, application by Matador Production Company for de novo hearing. May I have the appearances of counsel for this case, please?
Good morning, Chair Chang, Adam Rankin with the Santa Fe Office of Holland Hart, appearing on behalf of the de novo applicant in this case, Matador Production Company.
And good morning, Jackie McLean with Hardy McLean, on behalf of Permian Resources Operating.
All right, if I'm in the right case, I've got a one sentence filing application. Would counsel like to perhaps give us a little bit more information so we can understand the scope of the dispute and what may be necessary for scheduling or disposition of this matter?
Sure. I'll take a stab. Commissioner Chang, Adam Rankin from Matador Production Company. This is a compulsory pooling case in which Matador opposes a compulsory pooling order that was issued to Permian Resources. And the situation is that Matador has a unit, exploratory unit, and has plans to develop its own acreage within that unit boundary. And Permian Resources has proposed a competing space unit that partially overlaps acreage within the unitized area. And Matador objects to that inclusion of their own acreage into the spacing unit, and therefore seeking a de novo review of that pooling order. I've conferred with counsel for Permian. We believe probably need, I think it's less than 2 days, but to be on the safe side, we would ask for 2 days to walk through the issues. Essentially, it's a standard pooling case with the only difference being that one of the parties here at Matador did not file an application for pooling because it has acreage within its unitized area that it intends to develop.
Okay,
And it doesn't need a pooling order to do so.
right. Any other parties wish to chime in as to the scope of the dispute here?
This is Jackie McLean for Permian Resources. I believe that Mr. Rankin did a good job summarizing what the dispute is about. I think that we would add that at the hearing, it was clear that Matador did not really have a development plan of its own for the acreage. And that was one of the reasons why Permian Resources prevailed. And we'd ask that the commission uphold that pooling order. And that we be set for a hearing, as soon as possible, so that this matter can be resolved.
Forgive me if this is the chair again. Forgive me if this is, I'm confused here just a little bit. Matador is a subsidiary of Permian Resources, or who is Matador here?
Mr. Chair, Adam Rankin from Matador. Matador is a separate operating entity from Permian Resources. So.
And not represented in this matter?
Is by me.
Oh, okay.
Yeah, by me.
I think that it's a little
Oh,
confusing because Matador didn't have their own sets of applications. And we typically see, competing proposals and competing cases. And in this case, Matador had to file under the Permian Resources case caption because those are the only cases that are pending before the commission.
Matador is MRC. Got it. Okay.
Yeah.
Okay. If the parties, so we're talking about the usual 7-factor test here, right? Are there any part of those 7-factor tests that the parties agree upon? Are you able to confer with each other and narrow the scope of which of these factors are, I guess, the most in dispute? Is there any motions practice that might be able to help you narrow the scope of a hearing?
Adam Rankin here from Matador. I'll just say a couple of things. I think we would need to I need to go back and think about that, Mr. Chair, and happy to do so. And I'll confer with Jackie and Permian Council as part of that. I'll also just add that the parties are in discussions and have been in discussions, my understanding. And from Matador's part, I do believe there's some hope for that they will be able to resolve this before hopefully a hearing is set. So I commit to doing 2 things. One, pushing the parties to continue negotiations to see if they can reach a resolution, number one. Number two, I'll also confer with Ms. McLean to see if we can come to some agreement as to the scope of the hearing and whether everything's on the table, if we can come to agreement on any aspect of the factors that are going to be evaluated by the commission. And if not, whether we think there's any opportunity for motions practice to narrow the scope.
Great. Does that sound acceptable to the other parties?
Yes.
does that sound
that's
reasonable?
fine with- that sounds good to Permian Resources.
Great. For the commission's part, the commission's scheduling between the three commissioners can be quite challenging. And as much as I enjoy weighing in on y'all disputes, it tends to make nobody happy when I have to rule on when we have to rule on anything. So certainly to the extent that parties are able to come to a mutually acceptable agreement, even if it's only partial, I think the commissioners would join me in encouraging that to the extent possible. In that case, I know you asked for a rapid hearing, Ms. McLean, but I don't know that we have 2 days for you in December, in addition to everything else that's on our docket. I guess I will also open the floor to commissioners. Should we set this for a follow-up status conference with hopefully a more narrow scope of issues and maybe a list of witnesses with more specific timelines to exactly what you're looking for in a hearing at the December, so another status conference at the December 17th meeting that we have scheduled? Or I think the commission would be happy to take advice if you guys, if the parties would like us to try to put something on the books, but it seems like there might be an opportunity for parties to further develop exactly what you're trying to get the commission to do here.
I think it would be Permian Resources' preference to set a status conference as well as get on the calendar for a hearing before the commission. We would prefer January, but if that's not possible, I think there's February meeting dates as well. But that way I know the commission can get full very quickly and you don't have that many dates available. So I think it would make sense to set us for status conference as well as set that hearing date.
Just to chime in there, Commissioner Chang, I think having a status conference in December makes sense, and it will give the opportunity to provide some fire, I think, for the parties to work towards resolution and to identify and narrow the scope of the issues for hearing. I personally have a challenge on the January hearing date only because I've got a lot on my plate with rulemaking, findings of fact, conclusions. That date is not ideal for me. It's only, primarily because of that reason. February date would be preferable, just in terms of competing caseloads.
I think that's true, Ms. McLean, of just about all of the commissioners as well, as we're also we've got our January docket is going to be quite full already with likely deliberations on a rulemaking. Here's what I think I can do, or here's my proposal, and I'll see how the rest of the commissioners feel. But my proposal is that we block a hearing for February 12th tentatively, if the parties are able to squeeze it into one day. But that's all that meeting is noticed for at the moment. So if the parties can squeeze it into one day, then we'll reserve February 12th for you. But if you need more than one day, because it turns into a battle of expert witnesses or whatnot, and you've got a bunch of live witnesses to present with cross and whatnot, the commission will have to reserve the right to reschedule beyond that. Is that acceptable?
I think that is. I think that parties can confer. I think there's some procedural mechanisms that we can use to streamline the presentation of the case. So I think it's possible for us to do it in a day. Of course, I'll confer with Ms. McLean about it, but I think there's some ways we can accommodate that limitation on the schedule.
Okay. Is that, if I could turn to the commissioners, is that an acceptable tentative plan for the commission?
Mr. Chair, that works for me. Thank you.
This is Commissioner Poma. So, Mr. Chair, I do have a question.
Please.
Is that going to be the de novo hearing? Is that going to be the hearing for the commission to accept the de novo hearing, or is the actual hearing itself?
The hearing itself.
Okay.
Yeah. No, I mean, we can actually deal with that today in terms of accepting it, because the de novo, if I understand that this is a de novo hearing as of right, so we don't really have a choice not to accept a de novo hearing. Yeah. We can only encourage the parties to resolve it themselves. All right. If that's an acceptable plan, I'm happy to entertain a motion to set a status conference at the December 17th meeting for this case, with a tentatively block February 12th for a merits hearing for this case. Anybody wish to move that?
Mr. Chair, so Commissioner Poma, I so move.
I second.
Thank you, commissioners. Without objection, so ordered.
Thank you.
Thank you very much. With that, we then turn to case number 25700. Do we have Lily and Warren Anderson on the platform?
Yes, sir. Yes, sir, Commissioner, I'm here.
Thank you very much. Just give us 1 minute or give me 1 minute if you could. Let me just pull up the.
So this is the court reporter. I heard a yes, sir, but I'm looking at all my people on my screen and I don't know who that came from.
That's me, Miss Apodaca. That's Warren Anderson and Lily Anderson.
Mr. Anderson,
Yes.
if you would spell your name for the court reporter, perhaps?
Okay, there's
Yes.
feedback.
It's got two.
Does he have two phones?
Hello, Miss Apodaca. Miss, this is Warren Anderson. WARREN Anderson, ANDERSON.
Great.
And just to let you know, I still don't see that name on my screen.
Madam
don't know.
Madam Court Reporter, can you hear me?
Yes,
This is Commissioner Chang. I believe Mr. Anderson is on a phone line, which is why he will show up as a phone number on the platform.
Okay.
It doesn't appear that Mr. Anderson has a camera with him, so I believe he will simply show up as a phone number. So given that, Mr. Anderson, for the court reporter, if you could please always start with your name and identify yourself when you speak. I'm sure the court reporter would very much appreciate that in order to be able to capture an accurate transcript of today's proceedings.
Yes. Okay. Thank you.
Thank you.
I will.
Thank you. So this is Chair Chang. Thank you. If you, this is, so we're here because of your application for a hearing or a de novo hearing of a case that was originally decided by the division's hearing examiner. Since you're the applicant, I will open the floor to you, sir, to I guess, advise the commission as to the scope of the dispute, and give the commission a little bit of context in what evidence that you might need to present so that we can try to figure out how best to chart a effective pathways towards resolving towards a fair hearing on your appeal.
Yes, sir. Ms. Court Reporter, this is Warren Anderson, WARRENANDERSON, phone number 310-980-4531.
Thank you.
Oh, okay, thank you. Yes, I would like, I'll give you a little, the background, on here. I'm seeking review and relief from the prior action of the division in the above caption matter. Landowners are record interest owners in lands affected by the application of Alpha Energy Partners 2 LLC and its affiliate, Paloma Permian Asset Company in Eddy County, New Mexico. Previously filed an objection and appeal to the division handling the above reference case. My grounds for in plea are that the prior proceedings were marked by I would say unfairness, including lack of transparency, insufficient notice, limited opportunity for meaningful participation, affected property owners. The operators at Alpha Energy Partners LLC and Paloma Permian Asset Company were afforded advantages not extended to the landowner, creating an imbalance where I had to prove a matter of good faith or not good faith.
Mr. Anderson,
Yes.
I apologize. This is entirely my mistake, but I believe I should have sworn you in before I had you begin your testimony, begin speaking here. Do you mind if I briefly interrupt just to swear you in?
No, sir. Go ahead, please.
Do you swear or affirm to tell the truth in these proceedings?
Yes, sir.
Thank you. And again, I interrupt or I apologize for the interruption. Please proceed.
Thank you, sir. The operators, Alpha Energy Partners 2 LLC and the Paloma Permian Asset Company, I believe were afforded advantages not extended to the landowner, creating an imbalance of access of information since I had the burden of proving not good faith or not good faith. And I thought I did that, but so the result of the division's prior action effectively sanctioned as arrangement that is inequitable and inconsistent with the protective process of the New Mexico and Gas Act, which guarantees correlative rights and fair dealings among the parties. The terms proposed through the Joint Operating Agreement, the JOA, and related filings imposed unreasonable, one-sided, and excessive burden on us, the landowners, contrary to principles of equity and fairness, and again, good faith. So those are the grounds. In my, do I need to go on with my argument?
I think that's helpful for us to get started, sir, since today, all we're doing here is a status conference to try to figure out the scope of what the dispute might be and to try to figure out how best to squeeze an actual, or if we need to get to a whole trial, or what what the process is here. So I think that's a good enough start. Let me turn to, and I apologize for doing things out of turn, but if I could have appearances of counsel for the other parties.
Yes,
You muted yourself, Mr. Savage. This is the court reporter.
You don't unmute your.
oh, I don't.
Yeah.
Morning, Mr. Chair, Commissioners, Council, and interested parties. Darren Savage, Deputy Shield, appearing on behalf of Alpha Energy Partners 2 LLC.
And I haven't yet entered a written appearance in this case, Mr. Chair, but Adam Rankin with the Santa Fe Office of Holland Hart. I will be entering an appearance on behalf of Sarvis Permian Land Fund 1 LLC, U.S. Energy Development Corporation, and Sarvis Rockmount Permian Land Fund LLC, as well as for Permian Resources Operating LLC.
Okay. No other parties in this matter at this time, right? That you know of, Mr. Savage, at least?
That's what I know of.
Okay. Well, Mr. Savage, I will turn to you then, as the other entered party at the moment. Could you please help us understand, at least from your perspective, the scope of what is in dispute here, whether this is a case that could be decided on motions, or whether or not this needs any testimonial evidence or document, or whether this can be decided by documentary evidence.
Yes, thank you, Mr. Chair. So under the Oil and Gas Act, a party is required to make attempts to reach voluntary agreement before they may proceed with a forced pooling. And the nature of those efforts and negotiations should be viewed under a lens of good faith, and good faith should be satisfied. My client, Alpha, they negotiated in good faith and they provided evidence to that effect at the division level. We have we've submitted a motion for summary judgment that goes over the commission orders and policy that define what good faith is. And then we provided evidence of all the efforts that Alpha has made or had made to reach a good faith agreement, a voluntary agreement. Efforts were not successful. As a result, we listed Anderson's in a pooling proceeding and proceeded to pool in which the division approved. We have on file a motion for summary judgment. I think this can be addressed with the response to that summary judgment administratively, and the commission could rule on that.
Okay, so your position is that this could be decided on the merits. Let me turn back to, so again, this is Chair Chang again. Let me turn back to Mr. Anderson.
Yes.
Mr. Anderson, I understand you filed it looks like you tried to file or send us a pleading this morning, but we got what appears to be a picture of just the first page. So it has not made its way to us. If you are, or at least we've only got the first page of what you seem to want to file. So I want to let you know that. So if you might want to try that again.
Okay.
What you just heard from Mr. Savage is that the other party in this case, or at least the party that has entered an appearance, believes that the dispute here is primarily one of law, not one of fact. So it is their position that this case may be decided on written arguments, and that there are no sort of credibility or factual issues that where we would have to have live witnesses come in. Typically, these motions are resolved before the commission has to decide on motions for summary judgment before we proceed and figure out exactly what the scope would look like in a full hearing to try to figure out what scope of the issues are. Have you had a chance have you gotten the copy of the motion for summary judgment?
But I don't think so.
Okay. You can I imagine
It was served by email, but I'd be glad to.
provide us
Again.
a courtesy copy. Yes.
Yes.
All right. The commission needs to, all right. I think the proper order of things here is that we will need, the commission is going to need all the parties, including Mr. Anderson, to review and respond to the motion for summary judgment that has been filed. And I think the commission needs to consider those motions before we can properly decide the scope of a hearing and therefore figure out how to set and what to set on our calendars for a hearing. Mr. Anderson, could I also put you on our December 17th meeting for a status conference and potential motions practice?
Yes, sir.
And I ask you in the meantime then to, we'll do our best as well, either through Mr. Savage or through Commission Clerk, to make sure that you get a copy of the motion for summary judgment.
Yes, sir.
And we would ask you to file a written response to the motion for summary judgment. In the motion for summary judgment, you will see arguments of law, which you may take issue with and you may disagree, and you may respond to those arguments. But in a motion, and just so you know, a motion for summary judgment, and I'm sure the council here will help me if I get the standard of law incorrect, but generally speaking, the motions for summary judgment, when we review them as a commission, we view the facts in the light most favorable to the non-moving party. So we view the facts in the light most favorable to you. And the question is, even if we take all the facts in the light that is, to a reasonable degree, most favorable to your arguments, is there nevertheless enough facts to establish that this case can be resolved as a purely legal question and therefore avoid the complications, expense, and time and need for a more thorough and complicated or convoluted merits hearing, where we would have to go through witnesses, swear people in, take testimony, do cross-examination, so on and so forth. So hopefully that gives you a little bit of context as to what we're looking for. So with that, I think if that sounds acceptable to the parties, I will turn to the commission and ask if that's that plan for us to set, to ask the parties to respond to the motions on the table in front of us, and to set this matter for a status conference and motions practice at the December 17th meeting. Is that acceptable to the commission?
Mr. Chair, I concur.
This is Commissioner Puma, Mr. Chair, I concur as well.
Just for formality's sake, if I could get that as a motion, Mr. Bloom?
Mr. Chair, I so move.
Mr. Chair, I second Commissioner Puma.
Without objection, so ordered. Great, thank you all. We will see you in December. And Mr. Anderson, if you have any difficulties communicating or obtaining the files that you need, or making sure that whatever pleadings you might want to file, please do not hesitate to reach out to Commission Clerk Sheila Apodaca, and we will do our best to ensure that your filings are properly received.
Yes.
Thank you.
Oh, are we finished?
That's it for today. Yep, we'll just wait until you have a chance to review the motion for summary judgment, and we'll wait for your response, written response to the motion for summary judgment, and we'll see you in December.
Okay, thank you, sir.
No problem. Thank you.
All right.
And now I'll turn our attention to case number 25694. And actually, my impression is that cases 25694, cases 25695, and cases 25696, if they haven't already been consolidated, probably should be consolidated. Is that correct?
That's correct. And
Okay. Well, in that case, I will call all three cases at the same time. May I please have the appearances of the council and or parties for these three cases?
Jonathan Samaniego, representing American Energy Resources, JONATHANSAMANIEGO.
Thank you very much, Mr. Samaniego. This is Chair Chang. For the court reporter, since Mr. Samaniego also appears to be on a phone line and is not available as an image up on the platform, Mr. Samaniego, I will similarly ask you, just as we did with Mr. Anderson, to identify yourself when you chime in to speak so that the court reporter can capture a transcript accurately for us.
Yes, sir.
Thank you very much.
Thank you.
All right, give me just 1 second to flip to my binder to the right sets of cases here. Mr. Samaniego, you're the applicant here for de novo hearings. If I could, I will turn, or I'm sorry, let me first swear you in for these proceedings, sir. Mr. Samaniego, do you affirm or swear or affirm to tell the truth?
Can you repeat, please?
Do you swear or affirm to tell the truth in these proceedings?
Yes, sir.
Thank you.
Mr. Chair, I'm sorry, this is Commissioner Bloom. I'm just wondering who the other parties are as well.
Oh, that's right. I'm sorry. Could the other parties please also enter their appearances?
yes, thank you. Good morning. Darren Savage, Fabian Schill, appearing on behalf of Alpha Energy Partners 2 LLC.
Good morning, Commissioner Chair, Commissioners. Adam Rankin with the Senate Office of Von Hart, appearing on behalf of Sarvis Permian Land Funds 1 LLC, U.S. Energy Development Corporation, and Sarvis Rockmount Permian Land Fund LLC, as well as Permian Resources Operating LLC.
Anybody know of any other parties that have entered in this or that intend to enter in this case at this time? Doesn't seem like it. Okay. All right, I will turn back to the applicant. Could you please advise, and so Mr. Samaniego, this is just a status conference. So we're just trying to figure out here from the commission's perspective, what the scope of the dispute is, what evidence you intend to present, and how or what evidence you need to resolve the scope of whatever is in dispute. And we're looking for a efficient mechanism to resolve to narrow the scope as much as possible, and to resolve as many issues as possible, so that we can get to a hearing that is orderly and effective. So given that, if you could please advise as to your appeals or your applications.
Yes, sir. American is seeking relief from the division order 251, in case 25166, 25496, 25495. Alpha is compulsory pulling all interest in 1718, 22 South, 27 East, proposing the HSU unit. They infringed trespass and a hostile takeover and overlapped American SAIC unit, causing great harm. American is is going to use all exhibits that it has filed in each of the cases to present as evidence in the matter. And American is seeking at this time that if the cases are moved for the status conference, if we can go ahead, if the commission could go ahead and grant the emergency stay at this time, so that way all parties are protected and all collective rights are protected from harm from all parties. That way, it pauses the matter. That way, relief can prevail.
Okay. So you've got a motion for an emergency stay in front of us today. Well, you've got the you've got your 3 de novo appeals or applications. And then on top of that, you've got a motion for emergency stays of these 3 cases. I think I've captured that correctly. Great. Okay. Let me turn to Alpha Energy. Alpha Energy filed the response here.
So we have a response to the stay, and that's our primary concern right now. We also have, in terms of the scope of the hearing, we have proposed a legal theory that we believe would allow the commission to address these matters. And it's a 3-prong test. And, we recognize that the commission does not have jurisdiction to evaluate title itself, to evaluate the validity of a lease itself. But under the orders that require a party to present ownership percentages and ownership exhibits, the commission certainly has jurisdiction to review the amounts of ownership, comparisons of ownership, and there is discussion in those orders that a party is required to make a good faith claim and to be a prudent operator in the presentation of those kinds of ownership exhibits. So we believe that the commission can separate the good faith element out, separate from the evaluation of title itself, and look at what the party has done in terms of good faith efforts to collect and present the ownership percentages that the commission looks at, and what the party has done to show that it has been prudent in its efforts and that it is a prudent operator. So we would like opportunity to present evidence and have a hearing on that. But that is kind of tied into some of the reasons for denying the stay. So I have 14 slides that I had prepared to present that address a number of issues in which the behavior of AER, American Energy Resources, their bad faith or lack of good faith efforts, their lack of prudence is tied up to their standing for requesting the stay. So I don't know if you want to go through all that today, or
we may very well have time to do that, but let's take this one step at a time if I could. So this is Chair Chang again for the court reporter. My apologies. My apologies if I forget to say my name. So it seems like you're vaguely making a motion for summary judgment argument, but it's not been filed as a motion for summary judgment.
No, I don't believe it rises to the level of summary judgment because I believe there's facts that in dispute. There's
the title
material.
Okay.
Yeah. So we're not. So at the division level, the division ruled that there was not that AER did not present sufficient evidence to show that it was an owner in the units in some of the units. We agree with that, but we see it in terms of the jurisdiction that the division and the commission have. We see it more as the AER did not provide a good faith review of the ownership and present that to the commission of the division to show that it had standing to go forward with a stay or to even assert this matter as an appeal. So, so I think there's issues of fact at play, material fact. So I don't think you could do a summary judgment, but certainly a hearing that would allow the commission to look at the facts and the evidence and make a ruling.
But the evidence, though, that you're presenting would be all found in the underlying record, right? Because your argument is that what was presented to the hearing examiner is, in your view, whether other parties agree with you or not, is insufficient.
I'm sorry, Mr. Chair. Can you repeat that?
Is it tell me if I'm wrong, but my understanding of your argument then is that the primary evidence is, or your argument centers on insufficient evidence of a proper title search or chain of title or whatever that was at the underlying hearing, at the hearing in front of the examiner. Therefore, it seems like the primary evidence that you rely on would be the record from the previous hearing. Is that correct?
The record from the previous hearing plus the additional items that AER has provided. For example, they provided shut-in checks dated February 28th, 2025, which does not comply with the language of the circa 1960 leases. I mean, there's a variety of things. There's, the AER has self-reported in 2025 on that stake will, AER has self-reported 1 MCF production of gas per month. We believe that the reportage is highly suspect. Mr. Kaufman, the landman of Alpha, drove out yesterday to that well and talked to the pipeline company, and it looks there's no meter on that well that can measure any amount of production. The pipeline company had no idea who was operating that well.
So before we get into the whole merits argument,
yes.
I imagine Mr. Samaniego probably does not agree with you.
I'm just pointing out the types of evidence that we would want to present.
So it sounds like you've got, but many of that is documentary evidence, right? And then Mr. Kaufman is your one. So you've got one potential witness.
Affidavit. Well, the affidavit. There may be an affidavit from the enterprise company. There, we have photographs of the well. So.
Okay, so mostly documentary, potentially one witness. Okay. Hey, just give me 1 second, Mr. Samaniego. I will turn right back to you, but just hang on for 1 second. Mr. Rankin has also entered, so let me also just hear from Mr. Rankin real quick.
Thank you, Mr. Chair. We'll be monitoring this case and we'll be presenting no evidence. It may be at some point making a statement in support of Alpha, but that's where we are right now.
All right. Great. Okay. So let me turn back to Mr. Samaniego. My understanding, and tell me if I'm wrong, but my understanding is that this dispute, before we get into the faith part, what good or bad faith, this stems from a dispute over title. Isn't that? Do you agree?
Yes.
Okay. Is there any proceedings outside of this commission where this title, I guess what I'm trying to get at is, let me rephrase that. My apologies to the court reporter here. Is the title dispute currently being litigated in any other forum, like say district court?
No.
Okay. Is there any intention by the parties to perhaps resolve the title issues with a court ruling from a district court so that we don't have to get into the morass of trying to adjudicate good faith or bad faith claims of title, considering that I think all party recognizes that this commission is not, generally speaking, a court to adjudicate title disputes?
It's to be determined today.
Mr. Chair, I would just say that I think that these issues and noting the scope of authority of the commission is important because, the operators and applicants, they do not want to be held hostage by somebody going in and taking antiquated leases from the 1960s when clearly the group or set of leases that authorized the development occurred in the 2000s, and then use those leases and take advantage of what they perceive as a limitation and loophole in the divisions and commission's authority to evaluate ownership, and then use those leases to basically hold not only the commission and division hostage, but the good faith operators and the prudent applicants hostage. I think this is a very, very important case to establish some legal precedent that would allow the commission the tools and the legal theories to negotiate these kinds of situations when they arise.
I'll turn it back to you, Mr. I'm turning back to you, Mr. Semeniego. Yes, I'm trying to give you the floor, Mr. Semeniego. Go ahead.
I want to start off with Darren Savage statement just right now when he specified his claims as theory. And I want to go by his first statement at the beginning of his claim and argument as starting off by, this is a theory. So Mr. Savage is very good at changing the narrative of the matter. But the fact is that he's already made two statements that these are theories. Theories, okay? Alpha's title is compromised. Therefore, the division making any ruling cannot protect the core elective rights for the fact that Alpha's title is compromised. Darren Savage is not a regulatory agent working for the NMOCD. He's overreaching his authority, and for the division to allow counsel's attorney to present and act as regulatory for the division is erroneous and arbitrary. Okay, American has presented evidence of Alpha being not in compliance with numerous wells, but not having adequate financials. Therefore, Alpha has no authority in New Mexico, under New Mexico law, to operate in compliance. Therefore, Americans, all of Alpha's claims from this forward should be considered moot because it's hearsay and they're theories.
Commission counsel.
This is Zach Chandler, Commission Counsel. It appears the parties have disagreement on many things, but they have one point of agreement. Alpha wrote in its pleadings, Alpha recognizes the commission does not have jurisdiction to determine the validity of any title or the continuation in force and effect of any oil and gas lease. American wrote in its pleadings, Alpha's recognition that the commission does not have jurisdiction to determine the validity of any title or the continuation in force and effect of any oil and gas lease is correct. It appears both parties have agreed the commission does not have jurisdiction to determine the validity of the disputed lease. Therefore, I don't think the commission has jurisdiction to handle this dispute.
Yeah, we're not asking for the commission to make a decision whether a lease is valid. The orders that the commission looked at, in which for example, in the Silverback case, the orders state it's the responsibility of a party to make a good faith claim of title. Now, there's two components here. You can evaluate the validity of the title, and you can also evaluate the validity of the good faith claim. Those are two different evaluations. We're not asking the commission to evaluate the title itself. We're asking to evaluate whether the actions that the party took that led to that claim were made in good faith. That is a very important distinction, because otherwise these kind of situations are going to occur repeatedly. And the commission really is obligated under the Oil and Gas Act to protect correlative rights. And if the commission and division are not willing to look at evaluate what it has authority to evaluate, and that's the good faith component and the prudent component, then it will not be protecting correlative rights with the full authority that it has, in our opinion. So I really, that is a very to just throw out the baby with the bathwater by saying we can't evaluate title, so we're not even going to look at the elements that we have the authority to evaluate to protect correlative rights, to me, is not the best way to proceed.
I hear the distinction you are trying to make there.
I want to catch it, Rico. Savage said that it ended his statement with "in his opinion." All those pretty words are great, but those are his opinions. And he's trying to change the narrative of the matter for you to agree with his personal opinions.
Well, that's okay. What is your opinion then, sir?
That Alpha has infringed, trespassed, and overreached Americans' core elective rights and SAIC unit, and has abused regulatory and the division creatively to do his dirty work.
I understand that your perspective on that, sir, but would you like to respond to what the commission counsel has just read from one of your briefs, claiming that, because if we understand your brief correctly, in your brief, both parties told us that we don't have the jurisdiction here at this forum to adjudicate title disputes. Do you disavow that statement in your brief now?
There might be issue as far as the jurisdiction, the limitations, but there's no limitations on the obligations and duties of the division to protect core elective rights. There's no limitations under that. They all need to be protected. So regardless of how the commission moves forward with this, the emergency stay must be granted, because regardless of the determination, core elective rights are not protected. So the first thing in doing in protecting core elective rights is pausing, slowing it down, the emergency stay being granted so that we can slowly and cautiously resolve this matter, not rush it under a rug.
So the point I was trying to make earlier, I think, is that hopefully you can all understand why the commission would be far more comfortable if there was a court decision telling us clearly, one way or the other, whether, who has title here, right? Because then we know exactly who has, with title. If there was a clear title decision, then we've got clear correlative rights to specific owners here. Where
under New Mexico law, it takes a court order to terminate or expire a lease. Therefore, there can't show a demand of release that proceeds action. Therefore, Savage's theory of him having superior leases is inadequate. It's erroneous. It's wrong. Therefore, Alpha's leases are top leases, and Americans, because there is no demand for release, that proceeds any action, holds American SAIC lease and leases superior.
Hang on, Commission Counsel?
This is Zach Chandler, Commission Counsel. The way I understand the dispute is that American claims it owns certain leases. Alpha claims that those leases have expired, and then they met with the leaseholders and they took over the lease. So it appears there is a dispute over who is the leaseholder or the lessee.
Does Alpha's claims follow New Mexico law?
And so, again, this is Zach Chandler. It appears that American's response is no, there has to be a court order before our lease was expired and then the lessors could then negotiate with Alpha to take them over. So it appears to be a dispute over the status of a lease.
Thank you, Mr. Chair.
I'm sorry,
Oh.
Commission Counsel, did you have anything further on? I didn't mean to cut you off.
I'm pausing.
Okay.
So thank you, Mr. Chair. So even if there is a title dispute that needs to go to district court, the Alpha can proceed under a valid pooling order while that decision is being made. And whoever prevails in district court, whoever the court determines is the owner, would still have the rights to whatever production in that unit that that Alpha developed or produced under a valid order. So in terms, if you decide to go that route and delay a decision until there's a district court order, that does not preclude Alpha proceeding with proper development under the pooling order. Now, let me point out
But it does.
one more point that's important. One more point that's important.
One second. Let's let. I
There's
will
no
turn back to you.
record.
I will turn back. I will turn back to
Jonathan
you, Mr.
Samaniego, I
Samaniego.
object. Jonathan
No
Samaniego, I
record.
object.
One at a
In
time,
order, yeah,
one
in order,
at a time.
yes, in order for the court reporter to capture everything here and build a proper record, we need to do things one at a time. So if Mr. Samaniego, if you could hold on, I promise I will turn back to you once I let Mr. Savage finish his thought.
Thank you, Mr. Chair. So Mr. Samaniego is arguing that there is harm. There's some kind of harm going on with these owners in what he believes is his unit. Mr. Samaniego had an opportunity at the division level. He made an appearance. He presented evidence. He presented his argument about any harm to correlative rights. After a hearing, the division has the authority to approve overlapping units. And by issuing the order, they basically approved that the two units could coexist without any violation of, they did not see any violation of correlative rights. So there's no harm here for Alpha to proceed with development under the valid, what we perceive as to be the valid division order. And then if you want to delay a decision on ownership and who gets that production that's being produced in the Hollywood Star unit, then that would be fine as well. And then we could come back and then they can distribute the production accordingly.
Your point is basically that this would be resolved with money damages one way or the other, or whatever distribution.
Production would be held in reserve and then it would be later released.
Yes.
Okay, there was no record there just now, gentlemen.
My apologies. That's all right. I don't think I said anything that was that important. We will go on. I will turn back to Mr. Samaniego.
Everything in this matter is important. Okay, Savage claims that American presented evidence at hearing. Savage presented at hearing false claims that American owns a wellbore and no interest at all. The division moved forward in muting American from participating at hearing and didn't allow American to present its evidence at hearing because of Savage's false claims. And here it is today. He's changed the narrative of the matter that these are expired and terminated leases whenever he used his false claims of a wellbore to silence American at hearing and presenting this evidence. Further, by American not being able to present its evidence at hearing then and today, that's violation of due rights. That's violation of due process. American has not been able to protect its collective rights, and for the division to attempt to move forward in granting the orders as good faith efforts is erroneous and a violation of commission and division's obligated duties to protect core elective rights under these numerous false claims that continue to change over time. Americans' claims have been consistent. And in any hearing, any judge or jury would understand that an inconsistent story, it's not valid. And that's what Savage has continuously presented in this matter, and the division to grant them to move forward with their operations and the orders would cause great and severe harm to American's operations and its unit. American wants to go ahead and also present that if the division does sway to allow Alpha to operate, American is asking that the division deny Alpha's 200% penalty because the wells were already drilled, to deny the 1/8 royalty and bring it up to 25% royalty because that's under the State of New Mexico State Bill 23. It ruled that new leases, that's what Alpha's attempting to claim this through as new leases, they're offering 1/8 royalty, which is by far way under the standards of New Mexico law, which is 25%. So there's many numerous bad faith efforts through Alpha for profits, which I don't think no profit and no expensive money in any kind of development should have any superseding over the protection of core elective rights.
Thank you, Mr. Samaniego. I'm gonna cut in here. This is Chair Chang. Again, today is just a status conference, and we haven't even proceeded necessarily to motions arguments on the emergency stay. So it seems like everybody wants to argue, or everybody is eager to talk about the merits of the case here, but we need to do this in a somewhat orderly fashion. So let me turn to my commission counsel and the commissions for a minute here. The applications are granted because these applications are valid as of right. Is that correct, commission counsel? For a de novo hearing.
This is Zach Chandler, Commission Counsel. I believe previously the commission did issue an order that it was not going to hear a case until the case had been resolved in district court.
But there is no pending case here in district court, right?
This is Zach Chandler. I'm trying to remember the case. It's on the tip of my tongue, but the commission within the last 2 or 3 months had a case where it denied that it was going to hear the case. Mr. Samaniego filed a case in district court.
Mr. Chandler, this is Commissioner Bloom. I believe you might be referring to the case between American Energy and Silverback Energy.
This is Zach Chandler. That is the name, yes.
In Silverback, this is Chair Chang again. In Silverback, there was a existing court order from the 5th Judicial District, and or is that right, in Las Cruces? I believe there was a decision, though, in that case where the 5th District had ruled against chain of title. Isn't that the distinction here, where there is no case even filed here to resolve chain of title?
This is Zach Chandler. That was a case that was for the kind of the quiet title that was filed like 10 years prior to today's date. And it was used as, in my evaluation, as showing that the commission doesn't have jurisdiction on the validity of title. The forum for the jurisdiction and the validity of title is the district court.
But just like in the Silverback case, okay, until it can be resolved in a court of proper jurisdiction, the emergency stay needs to be granted to protect core elective rights until both parties can resolve the matter in the appropriate jurisdiction.
Thank you, Mr. Samaniego. We're gonna have, we need to have a little bit of discussion just with the with the commission for the moment. So
this is Zach Chandler. You always have options, okay? One option is to pursue the silverback route. Okay. That may be a productive option because I note that in that case, Mr. Samaniego filed an appeal in district court, but has now asked the court to stay his appeal of the commission's decision while he files a separate case to clear up the title. So it appears that Mr. Samiego's counsel, Mr. Candelaria, in the Silverback case, has realized title issues have to be resolved by the district court. That's one option. Another option is maybe it's time to peel off the Band-Aid in this particular case. I'm surprised the division is not here because there's allegations that the Saurik well, spelled S-A-U-I-K, is an orphan well. And we've heard a lot about orphan wells. There was material in the record that the division filed a notice of violation. This might have been an opportunity for the division to peel off the Band-Aid and resolve a lot of different issues. And maybe reach finality on the status of this well. Not only its ownership, but maybe more importantly, its orphan or temporary abandoned status. Or that may be in dispute, as Mr. Samaniego has said that he is now making steps to file certain paperwork to that it's not temporary abandoned. I'm still talking, sir. So that's another option if you want to peel off the Band-Aid and resolve a bunch of different issues at once that may have been festering since 2017.
well, even that commission counsel, I think, is, I don't know that we would be able to peel off the Band-Aid and resolve everything at a status conference. I'm just trying to figure out what we need to resolve today and how we set this. I don't know that I'm ready to make a sua sponte motion to dismiss without prejudice, certainly, especially since all the parties are aligned against, or at least have counseled against that. I would at least like to invite parties to brief the jurisdictional issues briefly before we do that. If that is, if we even want to do that, I would invite some briefing on that. Particularly if it's opposed by all parties. I'm happy to, I don't know, let me ask the commission's advice here, or the rest of the commissioners. Would you like to take the issue of jurisdiction under advisement, not rule on it today, but we can hear but we've heard arguments around it already. Take it under advisement for now and potentially reserve that as an option. And then also, does the commission also wish to hear debate on the motion for an emergency stay today?
Mr. Chair, I see that Mr. Moander, counsel for Emder and I think OCD, has his hand raised. Perhaps he would like to weigh in.
Well, he's not a party, so he would have to public comment.
That's okay, Mr. Chair. I recognize that fact. If I may just have a minute to make the following comment, if that's acceptable.
Sure.
OCD is happy to provide briefing or information, thoughts, guidance, et cetera, on this case. This is one of many with American, and it's increasingly clear there's similar disputes. So if the commission wishes to invite briefing from the division on that, that could happily be arranged and addressed per the OCD's pleasure or OCC's pleasure.
I see another hand raised. Is that you, Mr. Samaniego?
It is, and I have him disabled.
Mr.
Am
Samaniego,
I
it looks like
unmuted?
you're unmuted now. I think we should be able to hear you. Go ahead.
Okay, boy. And muting like that, it's inappropriate because that violates his individual's right to speak. And that's exactly how, through each of these hearings and all these matters, these operators pulling have prevailed through the ability to silence parties from presenting their evidence and for their claims. And just the way it happened, just right there.
Mr. Samaniego, we have given.
I'm not done. I given you the right to talk. I'm talking. Okay. I want the commission and the division to be aware that I have hired attorney Domenici, and he is handling Americans Regulatory, and we have been in talk with Jesse Tremaine with the division, and for the division to attempt to proceed, or the commission to attempt to proceed to violate American as stripping off a Band-Aid and violating through NOVs through previous operators would be a violation of due process rights under federal law. So since American is not in violation, American has adequate financials, and American is a prudent operator acting in good faith, those discussions today are inappropriate and should be considered hearsay, and they should be stricken from the record.
Mr. Samaniego, first of all, as commission chair, I can always interrupt you because I'm the chair here. Number two, if there is any muting going on, it's to ensure that nobody speaks over each other, but we have given you opportunities to speak just as you were speaking right now. And as long as everybody waits their turn, I will do my best to make sure that everybody gets a fair shot at presenting what they need to present, including you. Now, so putting that point aside, I hear you. Again, it sounds like everybody is chomping at the bit to get to the merit. Again, we're at a status conference at the moment. The commission has not even agreed to start hearing arguments on the motion for emergency stay. So all of these arguments around the actual disputes are a little premature until I can figure out and get advice from the commissioners whether they are in fact willing to entertain motions practice on the emergency stay today. So if I could get the parties to hold off for a minute, I'd like to get commissioners' input here as to whether or not the commission is ready to or wishes to hear any argument on the motion for the emergency stay.
Mr. Chair, this is Commissioner Bowman. I just want to know, is it not possible for all of it to be resolved at the district court? Or since it was a decision from the division, the commission needs to really act on it? I just want some clarity on that.
I think commission counsel can probably add to this answer, but I think if a district court were to weigh in on title one way or the other, it would resolve a lot of the issues here and would leave us with a much simpler decision to make, if any at all. That said, at the very minimum, the motion for an emergency stay, given that court proceedings, if the parties even go there, would take a long time. At the very minimum, I think we've got a motion, the issue of whether or not to issue an emergency stay of the division's order would be something that we likely need to make a decision on. Commission counsel, is there anything further, or did I capture that?
This is Zach Chandler. I have nothing further.
Commissioner Bloom, what is your pleasure? Or what do you advise?
Thank you, Mr. Chair. I'm struggling here with how to proceed.
I think all three of us on the commission, and probably Mr. Chandler as well, I think we're all struggling a little bit to handle this in an organized manner. I will speak only for myself. Noting the time, I'm willing to allow a reasonable amount of brief arguments from all parties on the motion for an emergency stay. And I don't know that I will be ready to make any decisions on anything today regarding this particular case, but I'm happy to hear the arguments, give parties an opportunity to say their piece, and take all of the issues, whether or not there is jurisdiction, whether or not there should be an emergency, or whether or not there should be a stay on an emergency basis, to take all the issues under advisement and then basically give the commission itself time to try to unwind the issues and invite written pleadings if necessary.
Mr. Chair, I think that's where I am too. I think hearing arguments could be helpful. I don't know that a decision, that I'd be ready to make a decision either today. So perhaps we proceed along the lines you suggested.
Dr. Mpoma?
Yeah, this is Commissioner Mpoma. So I do have a question though, because let's say the motion of stay, we put in that up to really discuss that. I mean, if the commission is also going to consider the de novo case, then it sounds like it's tied together. Because let's say if you deny motion of stay, then what would be the need for the de novo? Right. So I'm just looking at, if we go ahead and listen to the motion to more or less stay, and then let's say we deny that, and we still come back, or we're going to deny without prejudice so it can be brought back, or because I'm still less confused.
Well, that's what I'm saying. I think Commissioner Bloom and I are not ready to make any decision on either of those. My proposal is only to since everybody is here, to give everybody the opportunity to also present oral arguments on both questions. And then to reserve our decision on both questions.
This is Commissioner Mpoma. Thank you so much for the clarification. I support that.
Does that, Commission Counsel, does that give you any heartburn, or do you have any advice on how you think we might be able to handle that any better?
This is Zach Chandler. As I've said, you have several options. So whatever path you want to go forward, that's fine.
Okay. So perhaps all right, I'll turn it to the parties to, sounds like the commission is amenable to hearing arguments on the motion for emergency stay. So I will turn it to the parties. I will ask the parties to limit their initial presentations on that to 10 minutes, because I have a feeling there's going to be some back and forth. So,
Mr. Chair?
Go ahead.
Perhaps a 10 or 15 minute break before we move into.
That would be fantastic. Thank you so much. That would be fantastic. I second that motion. In that case, it's currently 10:45, or do you think it longer?
10:45 would be fine.
All right. In that case, let's take a break, and we will come back and hear arguments on the motion for the emergency stay at 10:45. Thank you very much. Thank you all.
Mr. Chair, I'm going to excuse myself. It's okay. I'll track the arguments back at my office. So
Can I join you?
Yeah, I'm going to try. I'm like, I understand. Like,
Good morning. I was about to say good afternoon, but I think it still is morning. Apologies for the few minutes of delay. This is the New Mexico Oil Conservation Commission. We are back on the record. Pursuant to the discussion that we just had prior to the break, I will now invite the parties to argue, to provide oral arguments on the motions for emergency stay of the three consolidated cases in front of the commission at the moment. Could I will invite Mr. Samaniego as the mover of the motion to start oral arguments. I do ask that we limit, Mr. Samaniego, I ask that you limit your initial remarks to 10 minutes so that we'll have some opportunities or time and opportunity for questions and or back and forth following your arguments.
Okay, do I begin?
Please, go ahead, sir.
Okay, I want to start off with Alpha's employed landman, John Kaufman. He stated at hearing under oath when asked by Samaniego about a lease terminating under specific laws or does automatically terminate. Alpha's landman, John Kaufman's statement was, it depends on the lease. And Darren Savage, Alpha's counsel, claims of the lease already being terminated and expired by their own landman statement at hearing. Savage's claims would be premature and at this time irrelevant. No, should be nothing more than hearsay at this time. So Alpha's counsel and landman statements conflict with one another. And American will further go that American meets the 4 prongs of the Tenneco. American is justly owed dues and will succeed in collecting its just dues on the merit. Second prong is that Alpha failed requirements under law and the final order that cause irreversible harm to collective rights owners, causing economic waste, and violating collective rights of owners through their willful failed efforts to notify and compensate interest owners, and imposing severe economic burden on the net returns, thus meeting the second element of the Tenneco standard. A stay pursuant to the Tenneco's third prong would not result in any substantial harm to other parties, as all owners subject to the order would receive their fair and just compensation due to the parties from the illegal oil and gas sales of Alpha. The last prong, in satisfaction of Tenneco's last prong, there is no harm to the public. In fact, the order is not stayed. The public will be harmed through acts of concealing a crime, mandatory reporting, and federal law in prison of a felony. So this is a crime that has took place. And I want to go on that Manning and Energy Minerals 206 NMSCC 027, showing that an administrative agency using its police powers to authorize a taking without compensation is unconstitutional and subject to the taking clause. So to move forward with granting Alpha the authority to move forward with its operations under these orders would violate federal law and would be considered unconstitutional under federal law under Manning versus Energy Minerals 206. The division and the commission cannot guarantee that core elective rights will be protected. So therefore, to not deny the emergency stay would be a violation of obligated duties of the division and the commission, the Oil and Gas Act, to protect core elective rights. And therefore, since the division would be violating their own law, state law, and violating federal law, it would be the commission and division should proceed with caution and grant the emergency stay so that this can be heard in the proper jurisdiction. At the same time, passing it as emergency stay granted so that core elective rights are protected, so that the division and commission would have done their duties. Thank you.
Okay, thank you. Commissioners, did you have any questions for Mr. Samaniego at this moment, or would you like to hear from Mr. Savage first before we open the floor to questions?
Mr. Chair, I think my preference would be to hear from Mr. Savage first.
All right, if that's all right with Commissioner Mpoma?
Yes.
I invite Mr. Savage to present his arguments.
Yes, thank you. Mr. Chair, Commissioners. First, I'd like to provide some context regarding chain of title. So every chain of title in a unit from patent to present has sensitive groupings of antiquated and expired leases that have been forfeited and supplanted by current leases. So for example, you could have early development in the 1940s, and you would, if you go through the chain of title, you would see the 1940s leases. Then you would have later development, let's say in the 1960s. Then you would see a set or group of leases that supplant the 1940s leases. And then you could see, for example, current development, and you would see modern leases in the 2000s. So this case presents a situation in which AER has obtained older leases from the 1960s and is using that claim of, it's a bad faith claim of these expired leases as a means to sabotage valid pooling orders. And this seems to be a recurring pattern that in other cases as well. Now, if the commission grants a stay, it's basically rewarding and endorsing a policy that anybody could go back to the 1940s. They could go back to the 1960s. They could say, "Hey, I want to buy these leases, buy them, and then throw a wrench into the proceedings at the division or the commission, and undermine the proceedings on no basis whatsoever, and enforce the good faith applicants and good faith operators to have to run to district court and pay enormous amounts of costs to try to work through this problem that was created by endorsing this policy." Now, the division found, and I direct you to the slide on the screen, the division found after AER had ample opportunity to provide a good faith showing of ownership in a number of cases involving the Hollywood Star Wells, they found and stated in the order, AER did not provide evidence demonstrating an interest in the unit. And then in the transcripts for the other cases, say AER does not have an interest in these cases. Now, that raises a serious issue about whether even AER has standing to request a motion to stay. Now, in New Mexico, standing requires, one, injury in fact, causal relationship between the injury and the challenged conduct, and three, the likelihood the injury will be addressed by a favorable decision. AER has no injury, number one. AER received due process multiple times at a hearing, stated its arguments, stated its positions. The OCD heard the arguments, and then they issued an order that approved the overlapping units. Now, the OCD, that is common procedure under the rules, that if somebody objects to an overlapping unit, the OCD will have a hearing, and then they will decide whether it violates correlative rights. In this case, they decided it does not. That is common practice. There are thousands of units out there with overlapping units that coexist. It's very rare for the OCD to deny or reject an overlapping unit. So therefore, there's no injury. Number two, there's no causal relationship. The OCD had the authority to approve the overlapping unit after a hearing and allowing both units to produce without injury. And then a decision to grant a stay will not address, that's the third requirement, will a decision to grant a stay actually address the injury, and it will not address any purported injury, but will directly harm the owners in the subject lands by impeding their just and equitable share of production from the pooling orders. Okay, so there's a standing issue that and that is the ACLU of New Mexico versus City of Albuquerque and New Mexico Supreme Court addresses. Now, the commission also considers the Tenneco versus New Mexico Water Quality Control Commission as the standard for whether to grant a stay or not. So the first one is the first prong of the test is, will AER is likely to prevail on the merits? AER is not likely to prevail on the merits. This is the first prong. It's the most important prong. So AER received due process of a hearing for its objections, and the division issued orders approving overlapping units as not violating correlative rights. We believe that should be recognized, and I believe that if the commission used the same standards under the rules for approving overlapping units, that they would come to the same conclusion. Now, Alpha appreciates OCC Council's comments they are appreciated, that if you pull back the wound, the Band-Aid on this, that you would see some very concerning issues and facts. Apparently, there's been a lot of festering over this well and other wells that AER has purported to operate. And Alpha has acquired a lot of evidence that Alpha is confident that at the OCC, that if this goes to hearing, that the OCC will find that the Sake well needs to be plugged. And that also is the reason that AER is not likely to prevail on the merits. So we have the two main issues there: approval of overlapping units. There's no violation there's no harm, no violation of creditor rights, and also if the commission is likely to find that this well will need to be plugged. On the second prong of Tenneco is AER has not shown irreparable harm. Approval of overlapping units is a common practice and authorization that does not result in irreparable harm to AER. AER has not shown any evidence of any kind of irreparable harm. And operators produce with overlapping units all the time without harm. AER's the third prong. AER fails to show substantial harm to interested parties. In fact, there are more than 700 plus owners in the subject lands and the units that AER has pooled. And there will be substantial harm to those owners because they will not, if you grant a stay, they'll be not denied, and their right to share of production would be impeded, and they'll be denied to their share of production, and they'll be directly harmed by the stay. AER, finally, the fourth prong, AER fails to show no harm will ensue to the public interest. Alpha contends that granting a stay will harm public interest by setting a precedent that allows a party to assert bad faith claims to go back and acquire assignments of leases that are invalid, and then use those to undermine proper good faith proceedings and undermine valid pooling orders and violate correlative rights. And that would be a harm. The commission granting a stay would incentivize and reward that kind of bad faith behavior, and it would harm the public interest. It would harm the good faith operators that do present, and then good faith applicants that do present ownership exhibits showing proper percentages of ownership in a good faith manner. Now, I'd like to address Commissioner Ampama's concern about whether granting a stay precludes or preempts a valid de novo hearing, and Alpha would say that it does. Clearly, it does not. There are two separate issues. There are two separate decisions. You can deny a stay and still go forward and have a fully valid hearing and hear all the merits and make a decision on the merits at a de novo hearing. Now, if the stay is denied, then the party who prevailed, Alpha, let's assume, would be in a position to decide what they wanted to do with that option. They would be the ones who would take the risk. If they decide to go forward, that's because they were incredibly confident that that pooling order is valid. If they make that decision and the OCC should decide otherwise, then they would have to deal with the consequences of that. And in a free market, that's something that I think an option of freedom that should be allowed. So given that AER does not satisfy Tenneco, which is the main standard for deciding this, but also the concerns that they do not satisfy even standing requirements for standing in New Mexico for asserting a motion to stay, we respectfully request that the commission deny the motion to stay. Thank you.
Commissioners, any questions for either party, or are we ready to just take the matter under advisement for the moment?
I have a response. Jonathan Samaniego with American has a response.
Fair enough. Mr. Samaniego, that's fine, but give me 1 second to ask the commissioners whether they have any questions, and then I'll turn to your response.
Okay, thank you.
Any questions at the moment, commissioners?
Mr. Chair, this is Commissioner Ampoma. I do have a question for AER, American.
Please.
So, sir, I do have a question for you. I want to know what is your thought process or the significance of force pooling?
I'm for compulsory pooling so long as it's done appropriately, properly, and within the guidelines of state law. If those are not followed, I think myself and the state under their own laws are all against it, if not done appropriately.
Thank you. So another question for you is, so as Mr. Savage presented to us, there are about 700 plus owners. So I want to know, are you the only party that is in dispute in this matter?
Here today, I suppose, if there is any other individuals pursuing action, I guess we will find out.
Thank you, Mr. Chair. No further questions.
Commissioner Bloom, any questions at this point?
No, Mr. Chair.
Thank you. In that case, I will turn to responses from the parties. I will give both parties a few minutes to respond. Please keep your comments to, I don't know, 6 minutes or so, no more, please. But I will start with you, Mr. Samaniego.
Yes, I want to start off by Mr. Savage, the way he ended his statement, requesting the division to grant freedom when it comes to their operations. And the commission or the division does not grant freedoms when it comes to protecting core elective rights. I want to go forward with that. The orders that were given in these cases were invalid and erroneous for the fact that American was not able to present its evidence at hearing in all the cases because Mr. Savage's false claims that changed over time from well bores to no interest to expired wells to NOV letters to other operators. They've been all over the place. I want to go forward that because Alpha, through their counsel, cannot pass not even the first prong of the technical matter, that involving NOV letters to plug wells, those are for other and previous operators. They have no relevance in this matter or relevance moving forward with those claims. Those need to be, that statement to be continuous needs to be mute and thrown out from being continually used as a claim because it's invalid. We can all see that. So the fact that Alpha, through counsel, cannot pass the first prong of the technical test, therefore Alpha's claims are irrelevant and should be considered moot because they don't have standing or merit against American, who is a prudent operator and passes the technical standards of the four-prong test for the emergency state to be granted. Thank you.
Thank you. Mr. Savage.
Well, I'll just make one comment. I don't understand why America AER was not able to present evidence at the hearing because of something I said. So just wanted to, he had ample opportunity to present his case. So that's all I would say.
Well, through the commission and the division, they take evidence and statements to make a determination. And Mr. Savage, when you present false claims and present evidence that over time changes and the stories are inconsistent, okay, it creates burden and on all parties. And what it created was the division to act in such an extreme manner because of the claims that you presented. So it made the Division Act erroneous. The division acts upon evidence being presented, and you willfully presented misleading evidence, Mr. Savage, and your landman and Alpha. So again, Commission and Division, I ask for the Division and Commission to move forward with the emergency state to protect core elective rights.
Thank you. We hear you now, and your comments are captured on the record. This is Chair Chang. Fair enough. At this point, any further questions for any of the parties, commissioners?
Mr. Chair, if you'd indulge me, a question for Mr. Samaniego.
Please.
Mr. Samaniego, Mr. Savage says that there would be nothing precluding you from having an overlapping unit here. What's your response to that?
I think moving forward on that statement would be premature because rights have been infringed and trespassed and overlapped upon.
And Mr. Samaniego, you were noticed as a party to this compulsory pooling, correct?
I was not. What I do is I spend a lot of my days, whenever I have the little free time, I spend it going through OCD records and agendas and hearings. And the fact that I came across this after permits were already put out there in the field.
Sure, if I may respond to that.
And as an operator attempted to enter an appearance and was denied because of false claims of Savage.
Okay, thank you, Mr. Samaniego. Mr. Savage, would you like to address that? That was my next question, was was a notification made to Mr. Samaniego and American Energy?
Yes.
No, there wasn't.
Okay, this is the court reporter. All I can see is something that says notice requirement. Somebody put up an exhibit. Now I don't see anybody.
Yeah.
Well, this is Chair Chang again. I'll ask anybody who's speaking while the exhibit is up to identify themselves as they speak. We're turning to Mr. Savage now.
So Commissioner Bloom, so an applicant, a pooling applicant, when they do an application, they must notify each owner of interest in the mineral estate proposed for pooling as evidenced by the record. Okay, and that's under 1915-412A1A. That's the criteria and the requirement. Okay. So Alpha satisfied this notice requirement by, number one, running good faith title to identify the current owners of the subject lands. Two, providing the division an ownership exhibit reflecting good faith presentation of ownership, all the owners. That was 700 plus. I mean, Alpha has invested millions of dollars by hiring title companies to run title on this. And then finally, mailing notice letters to mineral owners in compliance with 1915-412. Now, the Alpha's title, good faith title, does not show that that AER is an owner in the subject lands. Okay, so the division mailed their notice letters. AER did not receive it because they were not entitled to it under the rules, and the division found that notice was satisfied. Now, what Samaniego is referring to is that he claims that he had a right to notice because he was the operator because he was an operator of this safe well. But let me point out, let me put that in context. So these pooling hearings were initially initiated in 2024 under case 24944. That's when Alpha first started sending out notice and started initiating these cases. Now, at that time, Wildcat Energy LLC was the designated operator of this stake unit. Even though that's the case, and even though AER did not have ownership, AER became aware of the pooling cases, became aware of that case, and made an entry of appearance. They made an entry of appearance, and they made their position known. Now, AER did not file their C-145 change of ownership until 2.5 months later, January 7th, 2025. So they were not even the designated operator entitled to notice until long after they've already started making their appearances in these cases. Now, so Alpha felt that it was clear to Alpha that this other notice issue, and it has nothing to do with who gets notice for pooling because they have an ownership of record, because AER does not have ownership of record according to a good faith review of the title. But this other rule, 1915, 1615B9, provides for notice to operators regarding in order to adjudicate overlapping units. Now we see that rule as being satisfied because AER did make an appearance. They stated their position. Their arguments were fully adjudicated, and in the end, the division issued an order in which they approved overlapping units as not violating correlative rights. So we do not see an issue there, and we do not see where AER was denied notice or was denied due process.
I understand. So this is Chair Chang. I understand you have some objections, Mr. Samaniego, but let me just, if I could, real quick. I believe what I'm hearing from both parties is that Mr. Savage concedes that nothing was specifically mailed to AER. However, your position is that they were not entitled to it because, again, this goes back to the underlying dispute over chain of title. So,
I want to say that Alpha's claim of multiple millions of dollars to title and that should be the standing to allow them to move forward. It's irrelevant who spent millions and billions of dollars. It's irrelevant to the matter.
I understand.
So to use that as who spent more money as a defense, that's irrelevant. Also, go ahead.
I said fair. We hear you on that point, but I think we also hear that to the scope of the Commissioner Bloom's question, though, whether or not notice was provided to AER, I think I'm hearing both of you say that notice was not provided. The dispute is over whether or not notice was required, right?
Well, Alpha's claim to millions of dollars on the title search, I've seen evidence where Alpha purchased all of its interests from Uplift. Uplift Energy went out there and got top leases on a lot of American SAIC leases, went and got top leases, and in the evidence, it shows that Uplift assigned those interests to Alpha with no warranty to title. No warranty to title. And for Savage to make claim that notice was done because they did the title search, they don't even know what they bought. They didn't know that title came with no warranty to title, which any prudent operator would not acquire interests with no warranty. So they in multiple stages, they presented their claims with bad faith and misleading evidence.
Thank you, Mr. Samaniego. This is the chair here. I think we're getting a little bit afield from Commissioner Bloom's question. So I just want to go back to Commissioner Bloom. Commissioner Bloom, has your question been answered or do you have any follow-up to that?
Yes and no, Mr. Chair. Thank you.
Great. I think at this point, the commission, or I'm ready as chair to take the matters under advisement, to make no decisions today, because I don't think we're ready to make any decisions today. but I will invite commissioners to weigh in. Are you ready to take the matter under advisement and to reserve our decision? Or would you like to hear any more argument or ask any more questions, commissioners?
Mr. Chair, I agree with your thoughts on how we proceed.
Mr. Chair, this is Commissioner Puma. I also agree to that.
Okay. Well, in that case, thank you all very much for the spirited debate and discussions today. I think for the just for record keeping clarity purposes, may I recommend that we set this matter back for a status conference at our December meeting, just so that it doesn't fall off the back burner. But that I don't know that we're ready to commit to anything more than a status conference and a status update at December at the moment. But that commissioners will have a chance to review all of the submissions and to think through the arguments made today at the moment. Does that sound acceptable to the commissioners?
Mr. Chair, yes. And if you're looking for a motion, I would move that.
Okay.
Okay.
Second?
Yeah, I second.
All right. Sounds like we've got a plan without objection. So moved and so approved. So Mr. Semeniego, just for those of you on the platform, just to clarify, we aren't ready to make any decisions on anything related to this case today, but we are going to take everything that you have presented and all of the arguments today under advisement, and we're going to think about it carefully. And to make sure that this case doesn't fall off the back burner, we have place this matter on the December 17th meeting. At the moment, we're going to set it for a status conference. If there's anything that changes or if we're ready to proceed beyond that further or other motions or whatnot, we will make sure that we let everybody know before the December 17th meeting. Okay. With that, I will close out. I think we are ready to recess until the case for the afternoon. So with that, I don't think we need a motion to recess, so I will just declare, without objection, I will declare that the commission is now in recess until 1:30 p.m.
Thank you, Mr. Chair.
Thank you all very much.